This is Barry Zalma on insurance. I am an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to discuss the U.S. Supreme Court's ruling in a case called Campbell versus State Farm and its effect on punitive damages awards in the state of California, and that would be applicable across the United States. In California, punitive damages have long been a part of traditional state tort law, and the states have broad discretion with respect to their imposition of punitive damages. But because a state's system for awarding punitive damages may deprive a defendant of fair notice of the severity of the penalty that a state may impose and threaten arbitrary punishments, the United States Supreme Court has found that the Constitution imposes certain limits in respect to procedures for awarding punitive damages and to amounts forbidden as grossly excessive. Consider Philip Morris USA versus Williams, a 2007 decision of the U.S. Supreme Court. Although the Supreme Court declined to impose a bright line ratio, which a punitive damages award cannot exceed, the U.S. Supreme Court, guided by its history, concluded that in practice, few awards exceeding a single-digit ratio between punitive and compensatory damages to a significant degree will satisfy due process. Following the High Court's guidance, the California Supreme Court explained that ratios between the punitive damages award and the plaintiff's actual or potential compensatory damages significantly greater than 9 or 10 to 1 are suspect and, absent special justification, cannot survive appellate scrutiny under the Due Process Clause. This was Nickerson versus Stonebridge, a 2016 decision of the California Supreme Court. Since the U.S. Supreme Court attempted to limit the amount of punitive damages available to litigants to a single-digit multiplier of compensatory damages, courts in the various states have attempted to get around the limitations. California, always at the forefront of punitive damages litigation, continues to struggle with the issue. As noted, Gotti referenced 4 other plaintiffs on whose plaintiff, Pinrock, allegedly brought unmeritorious ADA compliance actions to support her claim for punitive damages. These allegations were proper to demonstrate the reprehensibility of Pinrock's conduct in support of Gotti's claim for punitive damages. In State Farm Mutual versus Campbell, a 2003 decision of the U.S. Supreme Court, the court held that the most important indicium of the reasonableness of a punitive damages award is the degree of reprehensibility of the defendant's conduct. Moreover, in Campbell, the High Court noted that its holdings that a recidivist may be punished more severely than a first offender recognize that repeated misconduct is more reprehensible than an individual instance of malfeasance. Similarly, the California Supreme Court has held that conduct is more reprehensible where it is part of a repeated practice rather than an isolated instance. In Johnson versus Ford Motor, a 2005 decision of the California Supreme Court. The California Supreme Court, the U.S. District Court of Appeal, have contributed to the interpretation posited by the U.S. Supreme Court in Campbell. The opinions address the following issues. 1. The proper ratio between punitive and compensatory damages, and 2. The proper weight to be given to evidence that the defendant aimed other similar misconduct at people other than the plaintiff. The California Supreme Court, for example, held that in calculating the proper ratio between punitive and compensatory damages, courts could consider uncompensated or potential harm to the plaintiff in addition to the compensated harm, but only if the uncompensated or potential harm was caused by the defendant's actionable misconduct. By so doing, the amount of compensatory damages available to multiply to reach a fair punitive damages award increases. The court also held that courts could consider the defendant's misconduct aimed at people other than the plaintiff, so long as the misconduct was similar, but ordinarily should not order the defendant to disgorge all its profits from similar misconduct aimed at others. The ruling on ratios probably will not benefit many defendants. In contrast, the ruling on misconduct aimed at others will benefit many plaintiffs, making both discovery and trials more complicated, although the court's skepticism about disgorgement remedies, when coupled with the ruling on ratios, may help cap punitive damages. Where there is no evidence that gives rise to an inference of actual malice, or conduct sufficiently outrageous to be deemed equivalent to actual malice, the trial court need not and should not submit the issue of punitive damages to the jury. When the plaintiff cannot produce evidence that the defendant acted maliciously, there are no triable issues as to whether the defendant is properly subject to punitive damages and is entitled to summary judgment on that issue. Where the plaintiff failed to purchase an office building from the defendant because the parties had no binding and enforceable agreement, a jury also found by clear and convincing evidence that the defendant acted with fraud, malice, or oppression, and awarded the plaintiff $2.5 million in punitive damages. On retrial of the punitive damages, a new jury awarded the plaintiff $1.7 million, and the trial court rendered judgment upon the award together with the $5,000 in compensatory damages. The California Supreme Court, finding that the jury's $1.7 million punitive damages award was grossly excessive, when the jury awarded only $5,000 in compensatory damages, and that at most an award of $50,000 punitive damages could be justified. It explained the need for reasonable connection between compensatory and punitive damages. The court addressed the issue of whether the actual damages on which a punitive damages award could be based could only take into account the actual jury award, or might also consider uncompensated losses suffered by the plaintiff. The court refused to allow consideration of $400,000 in alleged lost profit from the failed deal, since there was no evidence of a causal relationship between the defendant's misconduct and those damages. This decision was called Simon v. San Paulo, a decision of the California Supreme Court in 2005. The court stated that while uncompensated or potential harm may in some circumstances be promptly considered, in assessing the constitutionality of a punitive damages award. Here the defendant's fraud neither caused nor foreseeably threatened to cause $400,000 in harm to the plaintiff. Rather, the court found that at a minimum, California law requires conduct done with willful and conscious disregard of the rights or safety of others, or despicable conduct done in conscious disregard of a person's right will allow for punitive damages. Conscious disregard in California means that the defendant was aware of the probable dangerous consequences of his conduct and that he willfully and deliberately failed to avoid those consequences. The jury's finding that the defendant made false promises with the intent to defraud Simon shows not merely an indifference to, but an active intent to injure Simon's rights through affirmative misrepresentation, not merely non-disclosure. The Supreme Court stated, quote, "The disputed $1.75 million punitive damages award to Simon was 340 times his $5,000 award of compensatory damages. This qualifies as a breathtaking multiplier, far outside the single-digit neighborhood suggested by the High Court in State Farm versus Campbell. As we have already determined, moreover, the $5,000 compensatory award accurately measured the actual harm done to Simon, and Simon failed to demonstrate that San Paulo's Holdings fraud threatened to cause him substantial additional harm. While San Paulo's Holdings fraud qualified for punitive damages under California law, compared to conduct in other punitive damages cases, it was not highly reprehensible." Close quote. In Johnson v. Ford Motor, a 2005 decision of the California Supreme Court, it concluded that an award of $10 million was constitutionally excessive where the plaintiff's actual damages for odometer fraud involving the sale of a used car was less than $18,000. Unlike the issue in Simon, where the focus was on the potential profits lost by the plaintiff as the result of defendant's fraudulent conduct, the issue in Johnson was whether injuries suffered by parties other than the plaintiff could appropriately be considered. The Supreme Court rejected the plaintiff's contention that a punitive damages award could be justified based upon the disgorgement of profits earned by Ford throughout its entire course of conduct towards other consumers. The Johnson court avoided addressing the issue of whether a plaintiff could ever justify the size of an award on a total profits basis. The court concluded that it was sufficient in this case that the plaintiff's attempt to calculate punitive damages on a total profits basis was factually deficient, and therefore found that the Court of Appeal had correctly determined that the underlying punitive damages award could not be upheld on an aggregate disgorgement theory. Nevertheless, the Supreme Court reversed the Court of Appeal's holding that an award of 3-1 was appropriate, declaring instead that the Court of Appeals should have taken into account whether Ford's fraud was more reprehensible because it was part of a repeated corporate practice rather than an isolated incident. The Supreme Court concluded that Campbell has not created a new constitutional rule binding on the states, nor did it find that Campbell, in expressing a presumptive preference for single-digit ratios, intended to adopt a restrictive historical view of the purpose of punitive damages. The court found that California juries and courts are not required to ignore evidence of corporate policies or practices in assessing a defendant's culpability, nor must they consider the defendant's harm to the plaintiff in isolation. The Supreme Court expressly concluded, therefore, that punishment and deterrence remain a key goal of punitive damages awards. It said, quote, "We need not decide whether a plaintiff could ever, consistent with due process, justify the size of an award on a total profits basis. Our independent, de novo review of the record required by due process demonstrates that these plaintiffs' attempt to calculate punitive damages on this basis was fatally deficient." Close quote. So to determine if an award of punitive damages is grossly excessive, the court must consider, among other factors, whether the measure of punishment is both reasonable and proportionate to the amount of harm to the plaintiff by comparing the amount of compensatory damages to the amount of punitive damages. Punitive damages are imposed only on a finding of scienter, that is, an evil intent, and they serve the goals of punishment and no others. In contrast, they, 1, do not impose an affirmative restraint on disability, 2, are not historically regarded as penal, 3, do not apply to behavior which is already a crime, and 4, are only imposed in private litigation in which the government is not a necessary party. As only the clearest proof can override the legislature's express designation of such damages as civil, courts will conclude that the balance of the factors is clearly insufficient. Insurers should be aware that it is best to keep all promises made or avoid making promises the insurer is not willing to fulfill. When the insurer took on a duty that it failed to fulfill, it was held to not only breach its contract with its insured, but to require the payment of punitive damages because of the reprehensibility of its conduct. This video was adapted from my book, Zalma on Insurance Claims, Part 106, Second Edition, which is part of a 10-part treatise, Zalma on Insurance Claims, all available from Amazon.com as Kindle books and as paperbacks. If you found this video to be useful to you, please convey it to your colleagues. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future blog postings and videos. Thank you for your attention.